Hello, everyone. Scott Carpenter here from the Carpenter Law Firm Studios. The topic today, our last in our 2024 education series, handling dangerous residents. This topic is unfortunately one that we have to deal with in 2024. Unfortunately, there are there are dangerous people. My cough is dangerous, although I am not anywhere near you. I've been told it's an allergy cough, so we're not going to be too concerned about it today. So we're handling dangerous residents, and there are a number of introductory topics and issues that we can jump into here right away. The first one is that safety is paramount. There is this concern that if the association is aware of a dangerous resident and does nothing about it, that a jury could hold the association responsible. Now, there is this cynical idea that, well, isn't that why we have insurance? This bothers me tremendously. Early in my career, a young skinny lawyer out of law school, I had a client matter once where the builder developer left a 10 to 12 foot gap in a block wall. And the gap was an opening to the canal. Just imagine any canal here in Arizona. This one happened to be in Maricopa County, but it could be Pima County, it could be Navajo County, it could be Mojave County, it doesn't matter. Wherever you're watching, just imagine a gap in a block wall by the Greenbelt retention area. The developer left a gap, and the city permitted it. And a mother with young children came to the board meeting and said, please close the gap in the block wall. I'm concerned about my children playing in the playground area, wandering into the canal area, falling into the canal and drowning. Now, as many of you know, our canal systems are self-cleaning. What do I mean by that? Well, the shape of the canal in a trapezoid means that the water flows faster at the bottom. And that's why when people fall into canals, feet first, the water flowing faster at the bottom pulls them under. And many people don't realize this. And so people drown in canals thinking, oh, it's just water sitting there. No, it's not just sitting there. It's moving. It's cleaning as it moves. It's pulling the debris through the canal. And the woman, the mother was right. People drown in canals all the time. And she was right for reasons she may not have even realized. The canals are dangerous. They're extremely dangerous. More dangerous to adult-sized bodies, perhaps, than child-sized bodies. But regardless, she was correct to want the wall closed. And I was dispatched by my boss at the time, early 90s, when I was starting my career, to go to the board meeting at the board's request to deal with this request to close the wall. Now, for whatever reason, the board did not want to close the wall, perhaps believing that whatever the association had inherited was supposed to stay that way. And when I got to the meeting, I heard one of the scary things that I'd ever heard up to that point in my career, and frankly, in my life. And the board president, in response to this young mother, and of course, at the time I was married to a young mother, she asked again about closing the fence, and the board president said, a man about the age I am now, said, well, if there's a problem, if there's a an injury or a death. That's why we have insurance. Well, in that hypothetical, in that woman's concern, and there's a claim, there's an injury or a death. And I found that quite abhorrent. So, okay, I started this with safety is paramount. A jury might say, well, we have a dangerous resident. If something happens and you knew about it and you did nothing about it, do we have insurance for that? I don't know. Maybe you do, maybe you don't. But let's don't develop the bad attitude that, well, if something bad happens, that's why we have insurance. Something bad happened. Let's avoid that. Let's make sure that the something bad that happened isn't to you or someone you love. Something bad happened. That's terrible. Let's avoid that. So safety is paramount. We need to protect the community and the residents and the property of the community. But in red, let's develop the principled approach. First, the association is never, ever, ever under the law obligated to tolerate or endure dangerous people or conditions. That is not the law. The association is not obligated to tolerate or endure dangerous people or conditions. Strawberry Monster may or may not help my cough, but I'm going to try. The association is never obligated to tolerate or endure dangerous people or conditions. So let's talk about the types of dangerous residents. We have something in the law called the direct threat exception. This exists in fair housing law, but it really is about making reasonable accommodations. So someone comes along and says, I'm disabled and I want a reasonable accommodation. We have the direct threat exception. Now, when I think about the direct threat exception, I think about someone who is mentally ill on the extreme end, and they want to be accommodated, but their mental illness is to a degree of illness that is extreme to the point of being dangerous to others. And there are some examples that are provided by the Department of Housing and Urban Development. I'll give them to you. So basically, the law is that the association must provide reasonable accommodations for people with disabilities, but it excludes coverage, meaning the obligation to provide reasonable accommodations for individuals with disabilities whose tenancy, think of this as an apartment complex kind of problem, but it applies to us as well, where the tenancy or the residency would constitute a direct threat to the health and safety of other individuals, or whose tenancy, again, residency, would result in substantial physical damage to the property of others. And that's the citation to the federal statute. So here are some examples from actual case law. A court found in 1997 that a tenant who engaged in altercations with other residents, chased children with a knife, listened to loud, vulgar music, and made inappropriate sexual comments was a direct threat to his neighbors, and therefore did not have to be accommodated. That person was a direct threat. That was out of Louisiana. Here's another one. In an apartment, a tenant's nudity in front of residents, repeated failure to close a security door, verbal attacks on others, and placement of misogynistic signs in his apartment window all amounted to directly threatening behavior as well. That was in South Dakota. So this kind of behavior negates the obligation to accommodate these residents. So those are examples of direct threat. And so we see that every once in a while, but in the multifamily or apartment scenario, you can see where it's a little easier to imagine, but we don't have that. We don't screen tenants. We don't screen residents. We don't have people who are gaining residency after an application in nearly every case. They just show up. And so we don't have we do have the direct threat exception that does apply, but it doesn't come up with a tremendous amount of frequency. But it does underscore and underline the point I'm making here in red, that the direct threat exception highlights the idea that in housing, we are not obligated to tolerate or endure dangerous people or conditions. And the direct threat exception is part of what creates that point I'm making, which is that if someone is a direct threat to the safety of other individuals, or whose tenancy would result in substantial physical damage to the property of others, the housing provider is not obligated to continue with that tenant or resident. So the direct threat exception assists me in making my point here, that the Federal Fair Housing Act does not say that a dangerous resident or tenant must be accommodated. In fact, it says the opposite, that a dangerous resident does not have to be accommodated. So if someone says, well, I know I'm dangerous, or a parent of an adult child says, well, I know my kid is dangerous, but you have to accommodate him because he is schizophrenic. And that's a disability. Well, in fact, an adult in his or her 80s does not get to say to you, I know my adult child is dangerous, but he's disabled. He's got mental illness. He's schizophrenic. And you're obligated to accommodate his residency in, I'm making this up, Del Boca Vista condo in Scottsdale because of his mental illness. That's a disability. You have to accommodate him. That's incorrect. If the person and his schizophrenia is a direct threat. So I'm pausing for that to sink in for a second. There are a number of people, how many we don't know, who have children with severe mental illness, who do not know how to live with their own adult children. But they're people of means. They live in other places. They're people of means who live in Chicago. They're people of means who live in New York. And somewhere along the way, they acquired a condo in Scottsdale. Somewhere along the way, they acquired a nice little house in Yuma. Somewhere along the way, they acquired a nice little abode in Lake Havasu, Tucson, somewhere else, Flagstaff. And they've struggled with their child for many years. And their child has severe mental illness. And they finally made the decision, let's drive our child, who's now 50, out to Arizona and get them settled in the condo in Flagstaff. I'm making all of this up. And you are the professional community manager for the condo in Flagstaff. And the 50-year-old shows up in condo 37 in the condo in Flagstaff. Now, the condo in Flagstaff is owned by the John and Betty Johnson Trust. And the child is Johnson kid, 50 years old, at least looks 50. And at first you don't realize that the kid is severely mentally ill. But over some period of time, it becomes clear that this resident is severely mentally ill. Now, over some months, eventually the direct threat becomes clear. Other owners start to complain about the conduct at the pool. Other owners start to complain about the conduct in the parking lot. We'll call the person the child. Is a 50-year-old a child? Yes, we're all children of our parents for the duration of our life. The child, no matter how old we get, no matter whether our parents are still alive or not, we are all children. The child has confrontations in the parking lot, at the pool, and with you as the manager. And eventually, this direct threat conduct in bullet points 3 and 4 here on the screen becomes apparent. Not parent-child, becomes apparent that this person may be a direct threat. We still have to give serious thought to what the governing documents say, because the child's not an owner. What can we do about this? Is this a rental? It's hard to complete the hypothetical without knowing what the governing documents say. Is rent being paid? Is this owner on the deed? Have the parents thought that through? Can't complete the hypothetical completely. But undoubtedly, hopefully the CC&Rs say you cannot be a nuisance or create any offensive activities. We can send demand letters to the parents in Chicago over the conduct of their tenant, who is a direct threat for the altercations at the pool and in the parking lot and in the management office. The parents, as the record owners of lot or unit 37, are responsible for the conduct of the resident, the tenant, the child. And we may have to deal with it that way. And in my career, I've had many situations like this where the direct threat exception has to be dealt with, where the person who's in the unit is a direct threat, but it's really up to the owners to claim that they're entitled to the accommodation based on the mental illness. But we have to enforce the documents, the offensive activities, and the actual violations and the altercations. Sometimes boards and professional community managers skip so quickly to the resident in unit 37 has severe mental illness that we have to reset and go back to, there are violations here and we need to go through that process. We can't always just deal with the mental illness. Sometimes we have to go to the owners and go through the violation steps. This doesn't actually come up with great frequency, but what tends to happen, as I just mentioned, is that the owner needs to request the accommodation, and then the association answers with direct threat. There's sort of an order of operations here that doesn't always happen. we're not obligated to accommodate direct threat residents. Let's talk about registered sex offenders. This comes up every once in a while where the community receives a registered sex offender. Community receives a registered sex offender notification. And back to where I started, the young mothers become frustrated and expect the association to solve the problem. Now, we know a few things about registered sex offenders. First, we know that registered sex offenders are not a protected category under federal fair housing laws. Gender, race, national origin, sexual orientation, gender identity, these are all protected classifications. But felony status, registered sex offender status is not a protected category under fair housing laws. So if the association were to discriminate against a registered sex offender could not go to court and say, Your Honor, I've been discriminated against in my community association because I'm a registered sex offender. Now, we do know that there has been some argument that if registered sex offenders skew statistically toward a protected category, that perhaps there would be an argument. Do registered sex offenders skew Canadian? Let's say, for example, is there a statistical likelihood that there are more Canadians? And I'm making that up to be a little silly for the sake of making my point. I'm not Canadian, but if I'm just, for example, national origin is a protected classification. Then one could make the argument that when you discriminate against registered sex offenders, you're discriminating against Canadians. Well, people have asked this question for a long time. What is the statistical breakdown by race among registered sex offenders? And in 2018, there was a study done by an outfit called the Justice Policy Journal. And the abstract of this academic study says that there have been no studies on this topic, and that the current study is an attempt to fill the gap. In doing so, we, the study's authors, utilize publicly available registered sex offender data collected from each US state and territory from 2012 to 2014. So the study's now 10 years old in terms of the data, culminating in 488,260 unique registered sex offenders from 54 US territories. We, the authors, examined this robust data set and found that in every state except Michigan, and I'm not sure why, African Americans have a higher rate of inclusion on sex offender registries. However, they also found that the southern states have the least disparate rates of inclusion. Disparate meaning higher rate of inclusion of African Americans versus their rate of percentage in the general population. So if African Americans make up 12% of the general population, they're more than 12% among registered sex offenders, for example. And I'm making that 12% up. I don't know what the actual number is, but higher than the general population. So the data set here is more than 10 years old, but this would be a way that if a community association were to adopt, say, a registered sex offender amendment that says no registered sex offender CCR amendment can reside here, which I've done before. I've helped community associations adopt a no registered sex offender occupancy amendment. You can own, but you can't live here. The occupant who's kicked out could argue it's discriminatory, but it is discriminatory against registered sex offenders. We have to concede that, but they're not protected under the law. But the only argument really that makes any sense is that that would make any sense is if the registered sex offender could say, well, I'm in a protected category, and my protected category is receiving a disparate or statistically significant discriminatory impact based on the way the registered sex offender system operates. And this study would be an attempt to show that. But as I pointed out, the data is 10 years old to 12 years old right now as we sit here today. We also know that the reason people are concerned about registered sex offenders is that sex-related criminal offenses have the highest reoffense rate after release from incarceration. We call that the recidivism rate, and people who commit sex crimes have the highest rate of committing crimes again. There have also been studies that have shown that by the time a person is caught for their first sex crime, they have committed anywhere from 1 to 30 crimes for which they were not caught. Sex crimes, that is. I'm not sure how they've created or obtained the data, but there's some evidence in the social sciences that by the time someone's caught for their first sex crime, they've committed 30 or so sex crimes for which they were never caught, which is one of the reasons why obtaining a criminal background check on someone is a difficult metric. Okay, you get a criminal background check on someone, they were convicted of one thing. Is that the one thing they did, or the one time they got caught? And that's why sex crime convictions are so tricky. There's a reason why we register sex offenders. We're concerned about these people. If it's true that the one time they got caught was the 1 in 30 that they committed, the social science studies are legitimately concerned about it. So there's a website, it's quite good. I'm going to try to launch it and show it to you. Hopefully this will work. I should be good at this, you'd think. Try it here. Here we go. All right, this is the sex offender website. And I'm going to type in my office here at Gilbert and Guadalupe. So here we are, shows a house, it's an office, and there's an HOA down the street. It's called Breckenridge Manor. Anybody with Google Maps can see this. Green means it's an offender home. So we'll just expose this person. This is Colin Daniel Crowley. He's 47, 5'10", 205, skinny guy. He was charged and convicted of sodomy, and he's living there at 130 West Tumbleweed Court, Gilbert 85233. His that's his home. Offenses against children are in red, and got my camera right here. Down the street from my office, just a little west. You don't see this very often. There are very few women who are registered sex offenders. Shauna Baldwin, charged with sexual conduct with a minor, attempted, 55120, Quail Lane in Gilbert. Every once in a while, what we see happen is that this website, which of course is publicly available, this is all public data. When someone shows up in a community, people can get notifications from this website. And someone will come to your board meeting and say, what are you doing about Tristan Velarde, 6'2", 185, just moved in? And the board's flat-footed and says, I don't know what you're talking about. Well, he's a sex offender. He just moved into the community. And the board, of course, and the manager, flat-footed. Don't know what you're talking about. Well, it's because we're not monitoring the website. We're not on top of it as a proactive matter. And I'm not saying you have to be, but it's one of those things where, what are we doing in advance? And so what ends up happening, give me a second here. What ends up happening is what could happen, I'm not saying it does happen, but what could happen is that the registered sex offender hangs out at the bus stop, and all of a sudden something bad happens in the community. And then there's a mom comes to the board meeting and says, what are you doing about this person? They name the person. They send a letter to the statutory agent. They send a letter to the HOA, and they complain about the person by name. They give the address. And all of a sudden make accusations. You need to be watching for this guy. He's at the bus stop. He's watching every day. He's there at pickup. And now he's talking to the kids at the bus stop in the morning. He's talking to the kids in the afternoon. What are you doing about it? Well, unfortunately, if you were to call me after the person comes to the board meeting and to say, well, what could we do about it? Well, it's going to be tough. We don't have good arrows in the quiver for what to do other than send some letters, perhaps impose some monetary penalties. But to go to court and get an injunction to stop a resident from that kind of behavior, it's going to be difficult. But let's assume we do all of that. When the registered sex offender does a bad thing to a kid, and the parents sue the association for wrongful death, let's assume it's a very bad thing, the worst thing. They sue the association for wrongful death, civil case for $10 million. And the board throws up its hands and says, well, at least we have insurance. You don't have $10 million, let's say. What are we going to do? Well, first we're going to do is say, well, we're set up. We got set up. We got set up by the complaints. It's in the minutes. We have copies of these letters that were sent to us complaining about him. There's a record. There's a record of all of these times that the board was told, this is a bad guy. He's doing bad things. He's at the bus stop in the morning and the afternoon. He's approaching kids. He's talking to them. The association had ample opportunity to know what was going on. What did we do about it? He's a dangerous resident. So I'm concerned about this hypothetical where he is a registered sex offender, he's hanging out, and the association's on notice. What are we going to do in that situation? Um, and as I said, the arrows in our quiver are, they're there, they're not great, but whatever we have, we need to deploy them. And the cynical version is, well, geez, each of the arrows in the quiver look like they involve legal fees. Each of the arrows in the quiver look like they're sort of call Scott Carpenter, perhaps. Sorry about that. But we have to do something when the alternative is do nothing and let this creeper continue to do what he's doing and roll the dice and hope that nothing happens. It's the old question of, is our strategy going to be hope is the strategy? No, hope is not a strategy. So when the website says that a bad person's moved into the community, what kind of risk are we taking? Now, some people will say that sex crimes are crimes of opportunity, and statistically speaking, they tend to happen from people where the victim knows the perpetrator, and they often happen in families. And rarely do sex crimes happen from stranger danger, and that the guy lurking at the bus stop is unlikely to be the way that the sex crime occurs. Well, are we sure about that? Are we so sure that we're going to ignore this creeper lurking in the community and at the bus stop? How certain are we that his conviction, from what we can tell from the publicly available data at familywatchdog.us, that his crime was a family crime, a known family member victim crime, and that because of that, he's not going to pick a victim from the bus stop and we don't have to do anything? I doubt it. I don't think so. So we have our registered sex offender, dangerous residents, and then we'll circle back here to the adult child housed in your community by parents who don't know what to do with him or her. I've encountered this person many times in my career. I've been yelled at. I've been spit on by this person. I've been called names. I've been shoved. If I were not a person of some fortitude, I think I would have been pushed over. I've been pushed. And of course, the parents weren't there. I had someone else in the community tell me, well, he's our village idiot. I actually had someone tell me that. And another person, actually, after that person said he's our village idiot, say, well, the parents have housed him here. The parents live in New York. And so what I've learned, I learned a lot from that experience. The parents will admit sometimes to their own dilemma. They don't want to live with their child, but their peace, PEACE, their peace is enhanced by having their troubled child live in your community. It's not peaceful for them to have their troubled adult child live in their home. I mean, the parents are 75, 80 years old, their 50-year-old child doesn't bring them peace, but it brings them peace for their child to live in your community. I mean, imagine. You don't have to imagine. Maybe it's happened to you. As a professional community manager, you have to deal with their problem. I've got 3 adult children. I'm an empty nester. It's peaceful for my children to live elsewhere. And many people can appreciate that. I love my kids. I love when they visit. I loved raising them, but I love being an empty nester. People generally do not want their adult children living in their house, no matter what age. And when the kid is troubled and has mental illness, most people can agree with the idea it's peaceful for that adult troubled child to live somewhere else. But let's call it what it is. They don't really want that adult child to live in a mental institution or in a group home. I mean, in some ways, these are the alternatives. It's not hard to grasp that either. It's a group home, mental institution, or live independently in your community. And in some cases, barely living independently, lashing out, having problems, spitting on the attorney, shoving the attorney, calling the attorney names, using vulgarity, whatever the issue is, going to the annual meeting, acting normal, acting like they own the place, going into the management office, doing all those things. Back in the old days, bringing a proxy to the annual meeting. That's dangerous. But we don't know why. All we see is the external issues. So here are the rules of engagement. The solution, if we can. We need to have zero tolerance for dangerous behavior. And there's really no separation between dangerous behavior and dangerous residents. Absolutely zero tolerance. As I mentioned at the top, the law does not require that the association tolerate or enable dangerous residents. We are not required to house dangerous residents in any way, shape, or form. We need to have a quick trigger on engaging the police. And all other residents, owners, tenants, residents, we need to encourage everyone to call the police, no matter what the issue is. If there's a harassment, touching, assault, battery, whatever it is, we need to have a quick trigger on that. One of the things that I think gets in the way sometimes is misplaced compassion. Compassion can get in the way of what the law requires. A jury is going to hold the association accountable, but misplaced compassion that gets in the way of taking action is going to simply enhance the liability. Compassion cannot get in the way of our legal obligation. Our legal obligation is to provide a safe environment for the owners and residents. If a board member or a professional community manager cannot do that because of the need for, well, I feel for this person, I feel compassion for this person, then board service may not be right for that board member at this time. Some board members need to consider resigning and perhaps volunteering in a different way. Volunteer for a charity that works with adults that are troubled. It's a harsh thing to say, perhaps, but the association has a particular role. We collect assessments, we maintain the common areas, and enforce the covenants. It's really quite simple. Collect the money, maintain the common areas, and enforce the covenants. But if a board member's compassion for people gets in the way of those three things, then it may not be a good fit. That sounds harsh, and it is, but while on the board members need to focus on collecting the assessments, maintaining the common areas, and enforcing the covenants in the CC&Rs. But when the compassion for the dangerous resident gets in the way of collecting the assessments, maintaining the common areas, and enforcing the covenants, and providing a safe environment for all the residents, then there really needs to be a reconsideration of whether board service is a good outlet for civic volunteerism. All right, those are the 5 things I think we need to keep in mind moving forward into 2025. Zero tolerance for dangerous residents. And then one other thing that I will highlight again is really being vigilant about registered sex offenders and really giving some real consideration to how often we're going to check the database, what we're going to do about it, and whether a registered sex offender CC&R amendment might be something to consider as a project in 2025. Of course, if you adopt one, you got to be vigilant about checking when they move in. That's the other challenge you bring on yourselves. You do an amendment that says no registered sex offender occupancy in our community. Now we've got to be vigilant about checking the website. If somebody moves in, that would be a violation. That's something to consider too. All right, when we do webinars, we do questions in the chat. And I have a few minutes here, about 5 minutes for questions. Happy to do that. If not, happy holidays to all of you. Happy to have had you join me here live from the Carpenter Law Firm studios. My now famous green screen in my office at Gilbert and Guadalupe. Thank you all. Hope you have a good new year. And if there's anything we can do here at the Carpenter Law Firm, give me a call. Thanks.